today joined by Ekta ma'am. She is, of course, partner at Samvad, an accredited mediator, mediation advocate, but most importantly, a powerhouse of knowledge when it comes to her field, and most importantly, mediation. And we were just speaking the other day where I shared with her that there was this mediation that was taking place. It was a matrimonial dispute where the husband and wife had come to terms and agreement on 90% of the issues. They had an agreement, and then they said, okay, on the last day, which is the next, it was a court annexed mediation. So they said, okay, on the last meeting, we will just fine tune the last 2 or 3 points, and we'll draft a settlement agreement. And on that last day, the wife was accompanied by her father, and he came and he basically said that this is a no deal and we are not going to sign, and he took her out of the mediation, and that mediation failed there. So that's why I think there is an importance of having the right people in a mediation room, and Ekta ma'am had quite a few thoughts on that. So that is what we're going to be focusing on. Who are the right people and how to prepare for the same?
So, having the right people in the room sometimes requires a lot more thought than we give it. And I'm going to talk about it from the story of 2 failed mediations. So all my examples today, we have success stories in mediation, but there are a lot of experiences that you're going to take home from failed mediation. So I'm going to talk about 2 failed mediations. One where I was a mediator, and the other one where I was a mediation counsel. And in one story, we do everything that we can, but eventually still you don't have the right party in the room. So I followed, so this was where I was a mediator. There was a father and son, and the other side was a corporate entity. Went by the book. Do you have power of attorney? Yes, I do. And for me, somewhere there was a niggling thought that, this father has authority, but I want to see what the son says. Son refused to speak or be part of the mediation process, even on a Zoom call. Even when I suggested that I will go and I want to have a conversation with him. This doubt got stronger when after every mediation session, the father would say, I'll go discuss with my son. So for me, it became the son played a critical role. And I asked the father several times, do you think your son is going to be part of the process? Will he buy into it? He says, yes, I will convince him. This was actually a very difficult mediation. There was a lot of emotional baggage that was on the table. Trusts were broken. You had parties flinging out physically at each other. But eventually, I think after 3 months, there was a settlement on the table. The lawyers were brilliant. The lawyers were well prepared. There were situations where the father was not able to see the point. He was like, I believe this and I'm right. Senior advocates were involved to convince the father about his legal position. So a lot of work went into it by the counsel, who were fantastic. The lawyers were about to start drafting the settlement agreement. And the father came back and said, my son says no. And he wants what was originally suggested by us. So the effort of 3 months was just washed away, and there was no settlement. Because the son refused. I said, even at that stage, when we said, please bring the son to the table so that we can have a conversation. The father said the son doesn't want to be part of any of these conversations, and he says what we had asked for earlier, we will stick to that, otherwise we'll go to court. So in that case, even though effort was done, the right person on the table was actually the son, and he refused to be part of a process. So eventually the parties in the room reached a settlement, but it failed because you didn't have the correct person in the room. The second one was where I was a counsel in mediation. Highly emotional dispute between employer and employee. This was a court-annexed mediation. Employer was represented by lawyers in the mediation room. The lawyers approached the entire mediation as transactional. They looked at it from monetary terms, as in, you give us an offer, we'll give you a counter offer. Our client, who was the employee, wanted to be heard. The right person of sending something, even the mediator understood. Mediator also requested to send a senior employee of the office, who is a woman, to come and attend at least one session on mediation, so that hearing can go back and she feels heard by somebody who has a position in the organization. Eventually, because there was a lot of pressure from us, our client and the mediator, the company sent a junior HR person who came to the mediation table and said, I have no idea of this conflict. I was told to be here and I'm here. I have no role. I cannot agree to anything. I'm just told to be here. So she was not even counseled properly by the council or the company or to be on the table and say the right thing so that the other party feels heard. Again, mediation failed. And in this case, because it's a court annex mediation and there are ADR rules, we've actually flagged out to the mediation center saying the right person as per your rules was on the table, and please bring this notice to the court. So while the mediation file has gone to the court with the mediation failed report, it also includes the letter of representation by us as lawyers in the mediation saying people with proper authority were not on the table. So please consider it under the ADR rules. The matter is still sub judice, so we don't know what the outcome would be. And the mediation center said this is the first case that we've come across where, the authority to be on the table has been questioned. The power of attorney, because there were no power of attorneys given, there were no board resolutions given. So we said, what is your authority to settle? So we've actually questioned the people on the table itself. So again, if there was a person on the table here, this was a beautiful case for settlement. The settlement could have been just by an apology as well, and nothing more. But positional, lawyers on the table, no person to understand emotional dealings, no preparation led to the failure.
So I think two points that come out. Thank you. So I think 2 points that come out from the two cases that you shared. One is regarding there being a correct party, and second is preparation. So maybe I'll just ask those in the form of questions. How do you decide who is the correct person to be in a mediation?
So two things. One is, and when you're looking at mediation, it's not just the mediator. It's also your counsel who's with the parties in the mediation. Parties are only looking at their interests. They're looking at an outcome. But the preparation for that starts with the mediation counsel to figure out, okay, what is your client's interests and who are the necessary people you need to get on the table. Sometimes it may not be just the party, like in the case you were saying. So while, if I look at strictly from the law, it's the husband and wife who are interested parties and it's their resolution. But in this case, the influence on the daughter was very heavily by the parents. So involving the parents at each stage before settlement would have become, of course these are all things that come in hindsight, but having the right questions in terms of, would you want to consult your parents? Can I meet with your parents? You met with the mother, but can I meet with your father as well? Okay, who else is in a family? Brother is there. Is the brother, again, what is the real? So from a mediator, from a lawyer perspective also, to figure out, I will take the wife, but the lawyer will know family equations. So the lawyer then needs to bring the family equations on the table or have a conversation with the mediator saying, see, the girl will say a lot of these things, but you need to be careful about father, brother, uncle, aunt, because they can disrupt the process as well. So we will need to take a tie-in. So the lawyer needs to understand who are the key stakeholders, bring it to the mediator. Mediator then asks those questions. If the lawyers are not prepared, then the mediator also needs to ask who else is part of the larger pool of people who can influence a decision. May not be the party in the mediation, but have a significant influence. So for example, in the case of, say even here we're talking about people, but in the case of a company, I might have the founders on the table. But if the company has a private equity investment, and even if the private equity investment or strategic investment is a minority stake, but because being a sole person on the board, that person may have a larger interest as well. So if tomorrow there may be a settlement by the founders, how sure are you that there won't be an oppression, mismanagement, or a shareholder dispute, that will flow out of it because the founders did not take into account the view of your investors on the table. So it again becomes important to see who are the other stakeholders that could influence a decision, not necessarily be the party on the table.
So the people who are influencing decisions should be marked as stakeholders, and we need to address each of them.
So even if you don't bring them as a party on the table, you need to see how to design the process. And I'll go back to what Gokul said earlier. Mediation is a process. So the designing of the process also then becomes very important to see how do you bring stakeholders on the table to at least understand where they're coming from. And if tomorrow you need to translate that person as a party, then you bring the lawyers on the table to see how that has to be done. But there's a process.
And I think lawyers do play an important role. As a matter of fact, I feel for mediation to grow at the pace that which we want, it cannot happen without lawyers. And so that's where I feel that preparation is very important from a lawyer standpoint, not only preparing himself, but more importantly, preparing the client. How do you feel a lawyer should, or how do you prepare your clients before we go in to mediations?
So as lawyers, you always feel we have a good case, right? But when I'm looking at mediation, I'm looking at not fighting a battle in court to prove it, but trying to see what is that my client can get. So one is, of course, having that conversation with your client to see what is their position, what are they looking for. Also, if it's coming out of court proceedings or through things, is also understanding the view of the other party. Because it's, while I feel I have a good case, I'm sure the counsel for the other side will also feel they have a good case. And eventually, if I need to have a negotiation, because eventually if I look at it and I equate it to a transactional negotiation, because I need to negotiate with their other counsel to convince them of my positions. And to also understand, if positionally we can sort of agree on certain things, great. But there's always an underlying interest which is there. So I need to get that interest out. So if I don't study the positions of what have the other party has put out, I may not be able to ask the right questions to get that interest. Further, also see what is the legal position, if there's established legal position. So if I am on a wrong, if I am on a weak footing, but that's a critical point, I need to then strategize on how to address it. And I'll give an example. So this is again, we were counsel for mediation. It was court annexed, it came from an NCLT, employee filed for employee dues. If you look at it, very straight-jacketed employees have a great hand, but we had a technical issue that we had put out. We actually won on the basis of the technical thing. My client said, while technically under law, the employee doesn't deserve this, but I'm willing to pay. But I'm willing to pay provided we are able to have that conversation and he comes down a notch from his expectations. The lawyer for the other side was very positional, was saying that, I have a great case in court, we will win, and they did not read our brief carefully to understand that the technical issue means that his client had actually no legal rights. And we won on the technicality. So eventually my client was feeling bad, but he says, I cannot go and approach him and say, I'm going to pay you, because the person is already so, the relationship was very acrimonious. So he says, I was hoping that in mediation that conversation could happen between the two lawyers and they will agree on a number. But that didn't happen and we won. So it was, in the event my client was sad about the outcome, but had the other side lawyer prepared enough and the mediator pushed them, there would have been a settlement. So preparation in that case would have helped the other lawyer.
Yes, I completely agree, because a lot of instances that we see, even fellow colleagues, they'll go into mediation to saying, चलो देखते हैं क्या होता है, right? We'll see and then we'll plan. And I feel that the preparation before is important, and it should be built for as well, because that's something that we fear from doing, and we feel that only what I'm doing in the session is what I'm going to build for. But as a counsel, preparation is something that can help in. And sometimes what happens is when you're looking prepared, you're also able to engage with the other parties on the table. So one is how prepared you are, and it's also perception that the other party has. So if you're not prepared and you're not able to engage, and because if you're not prepared, you'll stick to positions. You can actually frustrate the other party out, which means while you could have had a good session and either had a settlement or not, but you could frustrate the other party out and say, I don't want to spend time on it because it's not worth the effort, because while I'm putting the effort and coming on the table, I don't see that coming from the other side. So while even in 2 or 3 sittings, if one of the parties sees that there's no effort from the other side, they will say, this is not worth my time. And since it's a voluntary process, they can move out. So preparation also helps the setting of the stage itself for further communication. Yes, I think it's important, because that's where we at the PACT and even at the Global Academy for Advocacy and Dispute Resolution want to create a community of lawyers, so that by 2030, when you're sitting in a mediation, the opposite lawyer is also a trained mediation advocate. And mediation advocacy is different from being a mediator. That is one, of course, you're being the neutral, and second is we're representing your clients in a mediation, and that is very, very important because that's where preparation and other things come in.
So the case where I was talking about, where which failed on things, but the parties were the lawyers were fantastic in it. They actually sat with each other. They actually said that we want to speak to each other. Can you give us a room? So they moved into a separate room. The lawyers spent time with each other, understanding legally where each of them came from, flagged out issues very narrowly, what they wanted to discuss, flagged out commercial concerns which they wanted the parties to touch upon, got the settlement between them on legal issues, and said, now because this is a commercial thing, these are the commercial. So they figured out that this commercial, they did the ZOPA. Okay, they did the ZOPA for the parties and said, between this, we have closed all the legal issues that need to be done. You have this ZOPA. Now we leave it to you to commercially agree on this. So they were that thorough. They sat with the documents with each other, minus mediator, minus parties, to say we will first close this out and then we'll come on the table because we believe it will be more productive. So
absolutely, yeah, it definitely does help having collaborative lawyers in the mediation. Just before Ekta, please, any questions from the audience?
yeah.
Yeah, hi. I'm an HR professional and a mediator, so definitely it makes it interesting to hear about the workplace mediations, opportunity and failures also. Few takeaways, yes, awareness is very important and the right person in the room is very important. Is there something else that we can do as HR? One thought I had was, do we have a mediation clause in the contracts that we signed, the employment contracts maybe? Are there things that we need to do in addition to the awareness that you just talked about?
So a mediation clause just tells you you're enabled to do mediation. Even if there's no mediation clause, nothing stops you from mediation. But as HR, it's very important for you to see what is the nature of the conflict and who to address. So assuming it's a conflict between two senior professionals, okay, which are there. Who else do you need in the room? Do you need to have some kind of a conversation before they get into mediation? Because sometimes what happens is you'll have two senior employees and you'll put a third employee who's senior to them to sit on mediation. But is there a conflict of interest? Because eventually they'll ask that question, you know what I do, so you should look at this more favorably to me. And the person who's sitting as a mediator is not really a mediator. So to see whether you need to get somebody external to look at some of these issues. So like I sit on a HR grievance committee, okay, where the only members in the committee are independent external members. So from an employee HR perspective, there is a gradation of how the escalation happens. It'll first go to HR. If it can be, resolved there, it's fine. If it cannot, then it gets escalated to this committee, independent committee. Independent committee's role is very, very small. If it is something which is high issues in terms of performance, etc., where you cannot look at it as an issue, you look at a relationship issue, you'll address a relationship issue. If it's more than a relationship issue, you send it back to the company and sometimes it goes directly to the CEO itself. So how, as an HR, you look at your organization ethos becomes very important to see how you want to structure dispute resolution.
Well said. I think some of these thoughts were resonating already, that because we have this something called a personal support service, psychological support, right? You have a link, you go there. You have internal links saying, okay, you can get coaching. So I have a coach also, so coach. But external being here is very important for mediation. Maybe a future is that you have another link which says mediation and you go external. So lot of
but
journey
how,
to make.
and if the earlier session was actually, somebody said very thing, how do you, Gokul again, I'm going back to first things. How do you look at words and power of words? The minute sometimes you say mediation, people will say I'm in a dispute. Sometimes they just want to be heard. Sometimes they want to address concerns.
Of course.
So like you said, you've called it a support group. So sometimes calling it a support group might help, but the process that is used is that of mediation.
No, I can tell you one thing. You rightly said that, if I go into that, it's perceived that I represent management, even though by core of the heart I'm not doing so.
Correct.
That's the perception that people will carry. Yeah. So that's the challenge.
Thank you so much. Thank you.
Thanks.
And
there was one more question. So,
can we take that offline?
Okay, we can take that offline if it's okay. Yeah.
Done.
Yeah.
Thank you so much.
Pleasure.
And thank you for supporting us through the years, Ekta. Thank you so much.
Always a pleasure.